As promised, Part 2, Corruptions in the Court and Banking. Legal tender. The primary basis of counterclaims is that all commercial instruments, such as promissory notes, credit agreements, bills of exchange, and checks, are defined as legal tender, or money, by the statutes such as Title 12 U.S.C. 1813 I 1, UCC subsection 1-20124, and subsection 3-104, subsection 8-1029, and subsection 9, 1029, 11, 12b, 49, and 64. The legal tender under the Uniform Commercial Code, UCC, section 1-20124, official comment. The referenced official comment notes that the definition of money is not legitimate to legal tender under the UCC. The test adopted is that of sanction of government, whether by authorization before issue or adoption afterwards, which recognizes the circulating medium as part of the official currency of the government. The narrow view that money is limited to legal tender is rejected. In light of the holding of Guarantee Trust Company versus Henward 307 U.S. 247, 1939, the federal U.S. Court of Appeals ruled on Title 31 U.S.C. 5118 as of October 27, 1977, legal tender for discharge of debts is no longer required. That is because legal tender is not in circulation at par with promise to pay credit. Requirements of repayment of debt is against public policy. Since legal tender was not loaned nor in circulation, they have not demanded payment in any particular form of coin or currency of legal tender, and repayment or payment need only be made in equivalent kind, a negotiable instrument. So when you went to the bank and you sign this promissory note, irrespective of what you realize you've done, you actually lent the bank the credit, okay, with a negotiable instrument. They whisked that negotiable instrument away, for which you failed to give a receipt for the value you created. Remember, when we go to the cash register and an item is purchased, what do they always ask you? Would you like your receipt? So if all businesses unanimously through the United States, from gas stations to banks, always offer you a receipt, don't you think it would be wise to join suit? Meaning, don't you think it would be highly intelligent that if you're issuing a negotiable instrument such as a promissory note, a bill of exchange, a private bill of exchange, an international bill of exchange, that you yourself would issue a receipt to the recipient of the accountable instrument, the value that you create, and have the one receiving it sign off on your receipt? You know, when I go to a restaurant and I pay with a card, the first thing they do is bring me a receipt and a pen. And they have me sign the receipt, and they keep the receipt, and they give me a copy. So don't you think you should be doing the same? Getting them to sign the receipt from the valuable negotiation that you've just exchanged with them? Being able to bear proof and evidence that Cynthia, a trustee for the banking corporation, received a negotiable instrument from you, that you created value, and that you can prove that you did so? Just food for thought. House Joint Resolution 192, Public Law 7310, and Title 31, USC 5118 prohibits banks, creditors, from demanding any specific species of payment. All banks must process lawful United States currency. Failure to do so is interference with commerce, a Title 15 violation. A felony under RICO Act Title 18 USC 1951. If you believe you have a lawful reason to dishonor this negotiable instrument, you must return it to the agent above with lawful reason and an affidavit in support, full stated and cited, sworn under your unlimited liability. Failure to provide lawful reason or reasons or to misdirect this instrument is grounds for a complaint to the FTC, Federal Trade Commission, under the FDCPA, Fair Debt Collection Practice Act, Title 15, 1692A1. It is your duty to honor this instrument for payment, to know, abide by, and operate under the law. Title 18 USC subsection 8 applies. Commercial instruments are legal tender for the payment of the debt in accordance with Title 31 USC 5118 and other statutes and codes. Failure to process and credit the intended account will result in a request of the Postal Inspector Office to investigate and audit the account balance sheet. Okay, and for the banks, it's the Money Net Daily Log Transaction Report 120, but you didn't hear it from me because you won't find it anywhere else. Optional. And file IRS Form 3949A information referral to the CID Criminal Investigation Division of the IRS. The UCC Uniform Commercial Code defines a negotiable instrument as an unconditional writing that promises or orders the payment of a fixed amount of money to be considered negotiable, and an instrument must meet the requirements stated in Article 3. UCC Article 3, Negotiable Instruments, subsection 3-104, Negotiable Instruments. Negotiable instruments means an unconditional promise or order to pay a fixed amount of money. B. Instrument means a negotiable instrument. FRNs, worthless. The Federal Reserve Bank, in its booklet, Modern Money Mechanics, page 3, states, in the United States, neither paper currency nor deposit have as commodities intrinsically. A dollar bill is just a piece of paper. Deposit merely book entries. The giving a Federal Reserve note does not constitute payment. See Eckhart versus Commissioners, CCA 42 FD 2D 158. The use of Federal Reserve notes is only a promise to pay. See Fidelity Savings versus Grimes, 131 P2D 894. Legal tender Federal Reserve notes are not good and lawful money of the United States. See Raines versus State, 226 S period W period 189. The Federal Reserve notes do not operate as payment in the absence of an agreement that they shall constitute payment. See Blashier, MFG Co. versus Harrell, HRRELL, 2 S period E period 2D 766. Federal Reserve notes are valueless. See IRS Code Section 1.1001-1, 4657, C period H period. That concludes the second video. The first video is directly below this one. Thanks again for your donations, all the assistance, forwarding on the knowledge and the literature to me to review. Let me see one more thing. I have one more thing to add to this that a friend sent to me that will help you with your banking endeavors, and I believe it should be right here. So let me see if I can open it. Oh, come on, baby. Mm-hmm. You're not going to let me open it, are you? Try again one more time for you guys. It is not going to allow me to open it. Let me see if I minimize this and go here. And again, we're talking about banking. Ladies and gentlemen, if you don't get into studying banking for the rest of your days, you will be a slave. And this I can guarantee. Alright, so, note earlier, Eisenberg first argues that any offer should be uttered as a promise, express or implied, to enter into a contract, writing to its terms in the event of timely acceptance. Obviously, argument blurs the distinction between express and implied issues, but that troubles him not at all. He notes that my promise implied rather than express. Indeed, it is often a matter of representation whether an expression is an offer at all. On this source, he, of course, quite right, as thousands of law students discover every day, it is indeed often hard to tell offers from other things such as preliminary inquiries, and it is the usual offer that actually contains express promise to enter into a contract. The implied and express distinctions plays little part at this stage because viewing an offer promise in the Eisenbergian sense nearly always requires a commitment that is not expressed. Now let me find back to banking here. Oh, don't tell me there's only one page. There's more. Alright, I opened the wrong one. Anyway, thanks for joining me. I will find the other title for you. I think it's Title 48 that states that any instrument or its equivalent, but I'll have to look for it again, folks. It's been a long night of studying, so appreciate you joining me. Thanks for all your donations and contributions, whether it be through literature, funds, whatever the case may be, credits on account. I sincerely appreciate it, and I hope this helps you.